Good evening, ladies and gentlemen, and welcome to the 29th webinar of the BASL webinar series. Today we are discussing insurance law and practice, and these are your experts. We have with us Mr. Nihal Fernando, President's Counsel, called to the bar in 1982 and was conferred Silk as a President's Counsel in 2004 with over 38 years of experience in litigation, practiced predominantly in civil and commercial law. He also has diverse legal experience specializing in insurance, intellectual property, construction, engineering, banking, finance, arbitration, and company law. In addition to being a lawyer, Mr. Fernando is also an accountant. We also have with us Mr. Razik Zaruk, President's Counsel. He's a diplomat and former chairman of a number of public corporations, and is a senior attorney at law in active practice who was enrolled to the bar in 1969 and was appointed as President's Counsel in 2006. He served in the diplomatic service as ambassador to the then Federal Republic of Yugoslavia and thereafter as the first ambassador to Hungary. Subsequently, he was appointed as Sri Lanka's High Commissioner to Singapore. He was also a member of the Sri Lanka delegation to the UN Human Rights Commission in Geneva and to the UNGA in New York. We also have with us Ms. Nimmi Gunaratna, attorney at law. Ms. Nimmi is a director of Aitken Spence Group Limited and the managing director of Aitken Spence International Consulting and Aitken Spence Insurance Brokers. She is the general manager of Lloyd's Agency in Colombo and the Maldives and is a director of Cynic Maritime Campus. She was appointed in the area representative of Indian subcontinent for the inaugural Lloyd's conference in London. We have with us Mr. Deepthi Lokwarachi, attorney at law, Mr. Deepthi Lokwarachi Group, Chief Executive Officer, Lanka Hospitals Corporation PLC, and has a career in insurance as a professional with 27 years of practice with local and international companies. He holds a bachelor's degree in law from the University of Colombo and also is an attorney at law who holds an advanced diploma in insurance from the Chartered Insurance Institute and is accredited as a chartered insurance risk manager and was a former president of the Insurance Association of Sri Lanka and president of the Sri Lanka Insurance Institute. Our moderator for this evening is Shivan Kanagiswaran, attorney at law. Shivan is a graduate in law from the University of Warwick and holds a master's in law in international business law from the London School of Economics and Political Science. He is a barrister of law of the Lincoln's Inn and an attorney of law of the Supreme Court of Sri Lanka, with an extensive practice in civil law in both original appellate courts and specializes in several areas, including corporate law, intellectual property, banking, finance, and tax law. Shivan, over to you.
Thank you, Tanya. Good evening, everybody, and thank you for joining this webinar on insurance law and practice. As the name suggests, it's a very broad area, but we are fortunate enough to have a very distinguished panel to guide us through it. In that regards, to focus on the topic, Mr. Nihal Fernando, President's Counsel, will look at insurance litigation and issues that arise for practitioners amongst other areas. President's Counsel Razik Zaruk will don the regulator's hat and give us an insight as to the regulator's perspective in the insurance industry. Then we have Mrs. Nimmi Gunaratna and Mr. Deepthi Lokwarachi. They are veterans in the insurance industry and also attorneys at law, and they will give us an understanding of the area from the point of view of insurance, the actual industry itself, thereby giving us a holistic approach to dealing with this very broad subject. Before handing over to Mr. Fernando, there are a few housekeeping matters. As you know, this is a 1.5 hour webinar. The first hour is dedicated to panel discussion, and the final half an hour is a question and answer session. So you all can post your questions on Zoom, and I'll direct it to the relevant panel member. Having said that, and I don't want to take any more time, so Mr. Fernando, sir, over to you. Sir, Mr. Fernando?
Okay. I have unmuted. Can you hear me?
Yes, sir.
Okay. Thank you very much. Good evening, ladies and gentlemen. As the moderator, Mr. Shivan Kanageshwaran, said, it's a bit difficult to go through this whole thing within half an hour to 20 minutes. So what I will do is I'll run through pretty fast the basics of it, and we'll deal with serious questions of serious matters during the question and answer time. To begin with regard to litigation, first thing to find out is what is insurance. Insurance is a contract. It's a risk arrangement for a fee. You arrange the transfer of risk for a fee based on a defined peril, based on a contract between two parties. Now, first thing that one has to do is to find out the terms and conditions of a policy. When it comes to litigation, that's a topic that is given to me, particularly with regard to litigation. If you are representing a plaintiff or a defendant in a case, first thing that you need to know in an insurance contract is whether the terms and conditions, you're within the terms and conditions of the policy. I must say here at the very beginning, there's a misconception that these contracts where the courts have jurisdiction to deal with reasonableness and whether it can be reopened. These are contracts between subjects to say they can't be reopened. It can be like in any other case, any contract, a contract can be reopened only on certain circumstances, that is mistake, capacity, illegality, or duress or whatever. Duress means economic duress, such as that. So these are not, this comes within the realm of private law and not public law. So the courts have no jurisdiction to talk about the decide on the reasonableness of an insurance contract. Then coming to the, why I say this is, most of the terms and conditions of any insurance policy or any insurance contract are standard terms of and conditions. Why is that? That is because you must understand what the nature of the insurance industry. Insurance companies, what they do is these take over the risk of an uncertain event of their client or customer, and they share it with others. That's called reinsurance. So you insure your factory for about 100 million. The insurance company will pass on 90 million or whatever amount that they feel that should be transferred to another reinsurance company. In turn, they will transfer it back again to someone else. So it's a global business going around the world. Now, although the reinsurance contract and the primary insurance contract is totally independent and different and distinct, that is why the policy conditions, the terms and conditions are the same. And that is why the English law books, the law text, case law are applicable when it comes to litigation. One has to understand that it is the profitability of an insurance company depends on the quantum of reinsurance that they do with regard to a particular risk that they take over. So having said that, let me first deal with what are the limbs of an insurance case, a litigation, insurance litigation. Fundamentally, there are two things that the litigator, the lawyer should know, or dealing with a litigation, to prove or to disprove. If you are the plaintiff, you got to prove it. If you are for the defendant, you got to contest it. That is, liability is one and quantum is the other. So when it comes to insurance litigation, there are two things. One, you have to establish your liability. Two, having established liability, you got to deal with the quantum. You deal with one and forget the other one, you lose your case. So when it comes to liability, to deal with liability, you're liable only within the terms of the policy. So you got to go through the terms and conditions of the policy and see whether you have a case within the policy. The peril cannot be outside the scope of the policy. It has to fit in to the policy. Now, how do you do that? How do you do that? You fundamentally, you must find out whether your client has a insurable interest in the matter for him to file action. Insurance depends on the insurable interest. I can't insure your house or your car. It has to be by the person who owns it. This gets complicated and advanced when it comes to different types of insurance, which I will deal with in a moment. But primarily, insurable interest is the key thing, and it is between two parties. There are exceptions to that rule. I will deal with that also at a later stage when it comes to marine policies, where open marine cover, the title passes, and the insured changes from time to time when the title passes. So that is primarily, that is the, when you look at a policy of insurance, first thing that you have to do is you have to look at the primary conditions of the policy. That is, what is it that is covered? Then in all these policies, there are extensions. For example, a fire policy will have a right and strike endorsement. Or for example, cyclone and tempest, malicious damage, aircraft damage, or various types of business interruption, various types of extensions. So those each and every extensions you have to read carefully. Whether what are the extensions, you have to read it carefully, see what are the exceptions to those perils that are covered. For example, in the export trade, if you export cinnamon, moisture damage is an inherent damage that can't be covered. So those are excluded in the policy. So you have to see whether your client's case comes within the policy and not covered by the exceptions. For example, in a ship insurance, unseaworthiness of the ship can't be covered. The ship only perils of the sea can be covered. If a ship is unseaworthy, then that insurance, you can't cover that part of the insurance, because what is certain can't be covered. It is only what is uncertain that can be covered, and certain areas which are specifically excluded must be dealt with. Now, then comes the quantum part of it. Quantum. Before I deal with the quantum, I will deal with the types of policies that are available in Sri Lanka and other areas. You can have a fire policy. As you know, in Sri Lanka, we are governed by the fire and life is governed by English law in terms of the introduction of English law ordinance. So fire and life is governed by English law. Rest and residue, the common law, South African, the Roman Dutch law governs all those other contracts. So the contract is governed. If it's fire insurance, and their extensions are governed by English law, and any other thing is governed by Roman Dutch law, which is the common law of this country. Now, there is fire insurance, there's burglary and theft, there's motor car insurance, third-party insurance, full cover and third-party insurance, there's marine insurance, ship insurance, there's cargo insurance, there's open marine cover for import-export trade, there's business interruption cover, which is a very hot topic these days due to the pandemic covers. Then there is health insurance is another area. So there are various types of insurance that can be taken. All the insurance covers that are taken relate to an uncertain event. When it comes to life insurance, death is certain, but the time of death is not certain. So that is the only area which is a different principle applies. But other areas, the principle is that it has to be uncertain, and it has to be within the contemplation of the parties at the time of entering into the contract of insurance. Now, ladies and gentlemen, to deal with these areas one by one, I will first quickly go through the Motor Traffic Act and the third-party insurance cover and be done with it, because there a lot of confusion in Sri Lanka about most of the cases. Outstation courts are third-party insurance cases. Now, as you know, contract of insurance, there is privity of contract between two parties. Now, here is a case where from the time of 1959, they passed the amendment to passed the law to say that in an accident, no vehicle can be put out to the road without an insurance cover to cover damages caused to an uncertain, unknown person. That is the third, called the third party. So a third party who is unknown to the insurance company is covered in an insurance policy which is taken by the owner, and without such policy, the owner is not allowed to put the vehicle onto the road. In 1951, this amendment was brought in, and subsequently it was amended in 2009. Now, here is the misconception that a lot of lawyers have, is that they think that these cases are insurance cases. That is not so. These are delictual cases for negligence, and they make the driver who is primarily responsible and the owner who is vicariously responsible as defendants. The insurance company takes over for the reason that any decree entered in such a case has to be satisfied by the insurance company. So for that reason, the insurance company represents the owner and the driver. So the policy of insurance between the owner and the insurance company not relevant to this type of cases. But end of the day, if there's a decree entered, the insurance company is obliged to satisfy that decree. Now, this went on for some time from 1951. In 2009, Act number 8 of 2009, they brought in an amendment to the Motor Traffic Act and said that if you are filing action against a owner and driver for damages or in an accident for death or injury, personal injury, not for property damage, only for personal and injury, you have to make the insurance company a party. Now, that is because there was a lot of corruption between the plaintiffs and the defendants. They used to get together and play out the sort of the insurance company. They say, look, because the defendants have to be represented by the insurance company to safeguard the liability of the insurance company to having to satisfy the decree. So there were instances where the plaintiff files action for 5 million and then there's the defendants don't contest it. We will share the loss, share the proceeds of the insurance, what they pay. So then the insurance industry lobbied and got this act amended in 2009 and brought in stringent rules to the Motor Traffic Act to say that it is a must that you have to give proper notice in terms of the Motor Traffic Act and to make the insurance company in every such case a defendant so that they can contest the quantum and ensure that the correct amount is paid enters as a decree which they are obliged to satisfy. So that is the legal aspects of the Motor Traffic Act. And I must digest a little bit. An authorized driver, owner of a vehicle authorizes a driver to drive. Now, all these years, you can't authorize an illegal person to drive. For example, you can't authorize your minor son who's a minor, 10 years of age or 12 years of age to drive. He doesn't have a license. He's not entitled to drive. It is illegal for him to drive. The policy conditions will always say that you can't, a person must, to drive must be a person who has a valid driving license, and he should not be under the influence of liquor. Now, all these years, up to very recently, about a few weeks back, insurance companies, when they find that the owner has authorized a person who should not be authorized in terms of the policy of insurance, has driven this vehicle, they file action in terms of the act, which is called a declaration of non-liability. Recently, there's a judgment of the Supreme Court, which was delivered very, very recently, has changed the law totally and said that person who drives on the 11th of September 2020, this judgment was delivered by Justice Gamini Amarasekar, who was a one-time Commercial High Court judge, a brilliant judge. He says that insurance companies are not entitled to ask for a declaration of non-liability if the owner authorizes driver drives the vehicle under the influence of liquor. He says that will defeat the public policy principle of enacting these amendments to the Motor Traffic Act. Insurance companies must pay, whether that case is they're reasonable in that case, and also there's a questions that arise with regard to whether you can authorize an illegal person with an illegal contract, exculpatory causa non marito, whether the legality cannot spring out of illegality, all those questions can be dealt with at a later stage. It will get clarified later, but the law has now changed. You cannot, insurance companies cannot ask for a declaration of non-liability if the driver is a drunken driver or declared to be a person who is under the influence of liquor. So this judgment is Kushan Idirivira versus Sadish Siva. I think Mr. Moderator appeared in this case. Shivan Kanagacharan appeared in this case. So this is a very important change in the law insofar as the third party motor traffic act is concerned. Now, having dealt with that, and one thing that you have to understand is that the main substance of this case, these cases are not related to the insurance law. These cases relate to delictual actions, but because the insurance company has to satisfy the decree, these amendments are brought in statutorily into the Motor Traffic Act. So having dealt with that, I will deal with the rest of the other policies of insurance and the other areas that I need to cover. Of course, in this area, in England, there is what you call no-fault insurance. That is also by statute. That is by statute. We don't have that. We don't have that. We have the common law principles. Common law principles, which is where you have to prove that only legal liability the insurance company has to satisfy. So all insurance company, they wait till a decree is entered for them to satisfy the decree. In England, by statute, they change the law, and automobile insurance in England is covered whether it's the fault or no fault. Otherwise, they have to pay. Now, having said that, with regard to the other areas of law which are there, types of insurance, when it comes to fire insurance, it gets extended by fire and strike endorsements. The flood cover, cyclone and tempest, each cover extension depends on another extension. For example, you can't get the terrorism cover without getting the right and strike endorsement. So in those cases, it is extremely important that you, when you are litigating, you have to understand that you have to come within the terms of the policy. There are warranties, there are exceptions, there are rules that have to be covered. Those things have to be dealt with very clearly. When it comes to litigation, you have to first find out whether the litigation has to be in a court of law, in a commercial high court, or a district court if it is less than 5 million or whatever, or arbitration. Arbitration is ADR, alternate dispute resolution. Those clauses are inbuilt into most of the insurance policies. If that is the case, then you can't file action in court without going into arbitration. Even the arbitration clauses, we have a recent decision in arbitration recently. There are two types. There were several types of arbitration clauses. There is the liability only clause. There is the quantum only clause. And the third one is the all risk or all disputes. So in a arbitration clause which covers a policy of insurance with regard to only the quantum, a dispute of a quantum, you cannot arbitrate in that. You have to go to the court and get your liability settled first, and then in the process, the other party is subject to the jurisdiction, the case can go on. So it is only, in fact, Mr. Veera, the person who was the insurance ombudsman, I forget his name, Vikrama Veerasurya, in his book, he says, in a quantum only clause of arbitration clause in an insurance policy, the person affected who wants to file action has to go to court. And there are they are called hybrid arbitration clauses. So you have to deal with those things. Those are practical problems that lawyers will face. They file action. There are time limits in the policy. You have to claim, if your claim that you submit is rejected, within 1 month you must file action, or within 1 year from the date of the peril. Then otherwise it is considered as forfeited. So now judges always, sometimes these questions are asked, why is this such a short period given? Isn't it very unreasonable when the prescription ordinance says that it is 6 years? There's ample authority for the proposition in England, in other countries, that limiting the prescriptive period or the time bar in an insurance policy is valid, because these are all reinsured and standard policies apply. And in fact, one person, I asked one of those solicitors, why these limitations are there? He said, just consider your main insurer, Sri Lanka insurance company, they must be getting about ₹1 billion worth of claims a year. You can't expect them to keep those things in their books for 6 years under the prescription ordinance. It is unfair. So then only we realize that this is just, there's something that has to be looked into in this. So those are matters that has to be gone into, and you can't keep a file with you for years till those periods lapse. You have to decide, the correct decision has to be taken, whether to go to court or whether to go to court or to whether to arbitrate. Then when it comes to the quantum, of proving the quantum, it's important that it is important that you deal with the correct amount that is due to be given. And as you know, insurance companies, you can't make profit out of insurance. That is a primary fundamental principle of insurance. You can't make profit out of insurance. You will get only what is due to you, not what is, you can't make profit out of it. So because of that, verify fee days is very important. For example, you insure a ship, they depend on the certificates. You insure your car, you give a declaration that the car has not been damaged by at the time of insurance. So the insurance company can't send their people to deep sea and see whether the hull is damaged or hull is corroded or the vehicle is damaged. They do inspect. You are expected to be honest and declare honestly in your policy what is the correct amount, the correct information. For example, for flood cover, you have to declare whether it is within the area, is there a waterway. Now, when it comes to flood cover, there are so many cases where water seepage, they try to claim on a flood cover. Water seepage is not covered under flood cover. Flood cover is a different cover, which will be dealt with. It is overflowing of water from a natural course. So likewise, if you declare something wrong, then as a defendant, you are entitled to take those positions in a case that is defending you. You're defending. When it comes to health cover, they ask you whether you got heart attacks, whether you got taking tablets for heart. There's one case which I did. I feel very sorry for that person. A person who got a health cover. I think Deepthi must be knowing that during his period when he was at Eagle Insurance, he he declared and said that no, I don't take anything. I'm clean. But within 1 month, he got a bypass done in Colombo, and they sent their investigators to Gaul Karapiti Hospital. He was in the list for about 3 years. He had been in that list. So you see, so this kind of thing, you have to be honest with the insurance company, because insurance companies are not expected to go behind people and find out the truth. They accept what the intended insurer says, insured says, and then grants the policy. Then you have to be careful with the one thing that I missed out when it was dealing with the motor car insurance, is that now the law has changed in 2019. Recently, in number 2 of 2019, they passed a new law called the Recovery of Damages for Death of a Person. Now, if you cause death by negligence, then the age-old principle, the Roman Dutch law principle that we can claim only pecuniary loss, is now outdated. It has been taken away. If there's death by negligence, now the law, by statutorily, the law says that you can claim damages for pain of mind. Then comes the conditions of a policy of insurance. There are the declarations, definitions, insurance agreement, exclusions, conditions, endorsements. All that has to be read carefully. Warranties. Now I will deal with the privity of contract part of it. Now, as you know, an insurance policy is between two parties, and it is only they who can insure. But there are certain exceptions that apply to import, export, trade, and marine insurance. They're what you call an open marine cover, which facilitates import, export, trade. You sell something in Sri Lanka, to reach, say, Chile or in South America, the, say, for example, tea exports, warehouse to warehouse cover is given, and they obtain a open marine cover. Now, open marine cover is one exception to the rule that is between two parties, because the person who can claim under that insurance policy depends on the person's title to that goods. As the title changes, the person can claim, and the documents of title goes along with this insurance policy. For example, you export tea, the factory owner gives it to the brokers store it in their warehouse, they go to the auctions, follow the hammer, the title changes, the new buyer takes over, put on board the vessel, it goes halfway sea freight, sea by sea, then again by inland trucking, then gets to the warehouse of the buyer. So the place at which the peril occurs, person who holds the title to the goods can claim on a marine insurance, open marine cover. That is one exception. It's a very interesting area because it depends on what time the title passes. Now, most of the export trade in products like tea, rubber, what do you call coconut, all those things, there are rules and regulations. Tea Traders Association, there are rules under the Chamber of Commerce, which is a statutory body. They pass regulations. There is tea trade, follow the hammer, the title passes. The rubber trade, they give you 7 days or whatever. So depends on that, the person gets the title, and that person is the person who can claim. In between, the broker holds on to the policy, the goods. And then brokers, they have what you call a spillover cover. In addition to the marine cover, they also insure because they are storing the goods. They are storing someone else's goods. It belongs either to the buyer, the seller, or the buyer. So a spillover cover is also available to the broker who stores the goods on behalf of the person who owns it. So these are slight exceptions to the rule of, they say that they have an insurable interest in regard to spillover cover. But other than that, if the goods are shipped on board the vessel, the title passes, the documents of title together with the policy is posted to the buyer abroad. Whilst the goods are in mid-sea, that person can sell the goods to someone else. So that person who buys the goods will go to the bank, pay the bank, get the documents of title endorsed in their name. Once the ship comes to the port at that end, he will go to the agent of the ship, the freight forwarding agent of the ship, and gets a delivery order, go to the port and collect the goods. So that, for example, if I import a car, I open a letter of credit, the shipper will send the vehicle here with the insurance. And the documents, the bill of lading will come with the insurance cover to me. So when it comes to me, whilst the ship is in mid-sea, I can sell this vehicle. I'll sell what I will do is I'll sell the documents. The bill of lading will, or the airway bill will be sold. And then that person, I will go to the bank, settle the bank, get the documents of title to myself, and then I'll go to the shipping agent, get the delivery order and clear the goods. And if there's any damage on board the vessel, I get the title, I get the right to sue the ship to recover the damage that it caused to the goods to which I have title now, although it is shipped by someone else to some other person.
Sorry to interrupt you, sir. This point. I can just go to just one clarification just before I move on to Mr. I actually, in that matter, I must say that I was led by Mr. Chandrakajaya Sundar, President's Counsel on the insurance matter. But Deepthi, on the point that Mr. Fernando mentioned about business interruption insurance, what is your input on that?
Well, let me put it this way now. Basically, when we talk about business interruption insurance, the traditional business interruption insurances are modeled on the basis that, when you own a property or when you operate a business, and when your business is affected due to a physical calamity affecting the affecting your insured property to be, not to be in a operating condition, like let's say if there is a flood or a fire, then in such circumstances, ability is actually the option is available for an insured person to elect a optional extra cover and cover your gross profits. So basically, when you cover the gross profits, all the overheads that you have otherwise have to incur, and what you have lost will be covered and provided by the insurance. So that was actually the traditional concept of business interruption insurance. But together with business interruption insurance, now we have instances where the activities of the business is not only affected by physical perils. Now, for instance, not only fires, not only floods that actually affect businesses. Now, on a limited purpose basis, like let's say that you have instances where power failures, where there can be prolonged power failures. I can actually give you an example. In the during the time that we had this confrontation between the north and the south, the military and the LTT. There was an instance where a power line that was actually supplying power to a terminal in the port, that was actually that was involved in supplying cement, got interrupted, and then that entity was actually not able to produce cement without power being there. So there was actually no physical damage, or there was no loss of property as far as the plant was concerned, but that was actually a public utility that was affected. So some policies actually recognize interruption to public utilities as well. Now, if you come to a situation of COVID like this, now we are experiencing COVID, and lots of businesses are affected as a result. So although there is no physical damage, some of the policies actually provide limited cover. It's actually not a large scale, very wide covers, but maybe about 10% of the sum insured or 10% of this expected turnover or something like that. You can quantify a limit, and you can actually buy a limited purpose business interruption insurance together with your regular business interruption insurance. So this insurance is now becoming increasingly common, but the fact is that many people are still not aware of the existence and availability of business interruption insurance. But right now, the trend is on the rise. That's the answer.
I think we might have. Sorry.
Can I interrupt just for one? Can I say few words about the business interruption?
Please.
Yeah.
Hello.
We
I
can
can't hear you.
We can hear you, sir.
Can you hear me? We can't hear you.
I can hear you, sir.
I can hear me. Okay, fine. Now, when it comes to business interruption, it's very important to understand business interruption. Now, today, the business interruption is mainly due to the contagious diseases clause, which is there are three areas. Now, for example, business interruption can be due to various points, as Lukwarachi said. But here we are now. Today, the hot topic is about the COVID-19, the damages caused to businesses due to COVID-19. Now, this is covered in terms of a clause which is called the infectious diseases and contagious diseases clause in the business interruption policy. Now, this policy has three types of policies. First is infectious diseases and contagious diseases clause. It covers only a limited area within the factory. Say your factory, if something happens within your factory, it's covered. This number two, second type is it extends a little bit more, say within the factory or within 10 kilometers or 25 kilometers of the area. So if something happens or a disease spreads in that area, then it is covered. Then comes the worst one is the pandemic cover. Very rarely that a pandemic cover has been obtained in the world. What I can see is that only once the Wimbledon tennis tournament was cancelled and they lost millions. The Wimbledon organizers lost millions. But laws that covered that a special pandemic cover was taken. When you say pandemic cover, pandemic is a globalized thing. So there is a lot of discussion, a lot of opinions given, and a lot of judgments in different places. In South Africa, they have held against the insurance companies. Some other areas they have held with the insurance, with the insured businesses. Now, pandemic, in my view, I think Nimi and Deepa can elaborate on that. In my view, we have given opinions to say that what the insurance company did not contemplate at the time of issuing this policy cannot be covered, because a general lockdown is not a contagious, doesn't come under this contagious diseases clause, which is traditionally defined and to mean within limited to the factory or to the limited area of 25 kilometers or whatever. So that is the situation today. And now people are getting pandemic cover, but it is not affordable to many companies because it is an extremely expensive cover, a pandemic cover, because the uncertainty is to such an extent so wide and uncertain. You don't know how long it will go on, particularly hotels. I mean, we know in hotels in Maldives, in other countries, even in Sri Lanka, they will have to, they get a pandemic cover. It's very difficult to get it because it's so, you don't know how long it will go on, how long it will spread, what is the radius, I mean, how far it will spread. So pandemic cover is available in the world, though very rarely. For example, tsunami was not available. Nobody took tsunami seriously. Now they take tsunami. But pandemic cover now, from now onwards, because of this COVID thing, they take the pandemic cover, which is very expensive. And the existing pandemic, existing contagious diseases and infectious diseases clause, the insureds, people who are affected are trying to cover that due to general lockdown under this clause, but the insurance companies are resisting, and there are judgments here and there. There are so many. I can give you articles where in South Africa they held against, and in England they have held with. So it is a matter to be looked into and decided later at a later stage. It's very interesting to see how they look at it. Thank you.
Yeah, absolutely, Mr. Fernando. I think he's absolutely correct in what he said, because general pandemics cannot be covered by insurance companies. And then if there is a general lockdown, that kind of a situation is not anticipated and envisaged under an insurance contract. Let's say that if the insured property is affected due to the pandemic and there needs to be a cleaning up exercise, and then as a result, if it requires to be closed for some for cleaning purposes, and then to until such time that the public confidence levels are built, for such purposes the limited purpose cover will apply. But by and large, for general lockdowns, the policies don't apply.
Thank you, Deepti. Mrs. Gujarat, I lost you there for a bit.
Yes, stemming from what Deepti and Mr. Nihal Fernando said, reinsurers are not willing to give for known risks. So future pandemic is what we are trying to ask. But COVID-19 is an exclusion, other than for those people who have taken it prior to the COVID-19 situation. There are policies globally active, but new policies are not being issued for COVID-19 under business interruption, but under a future pandemic. But that still we are yet to receive quotations from reinsurers.
Thank you. Mr. Razik, sorry for keeping on hold for so long. Just a quick question from what Mrs. Gunratha said about reinsurance. What is your take on that?
I think, Shwan, this is an area that will very soon, what shall I say, would erupt here in the course. We have already a number of claims having made on the basis of business interruption based on COVID-19. But whatever may be the polemics involved, whether it is contagious diseases or whether it is not a COVID cover, there's certainly a number of claims that have been made, particularly by the hoteliers, that they have been affected by this, and they have taken, and they say that they have taken adequate cover. And one cannot go behind and say, well, we did not expect this to happen, or this is not what we envisaged or to happen. So that may be a defense. But certainly I find that already a number of people have come up with these claims. And I think we ourselves as regulators are a little concerned. And ultimately, I have a feeling that all this will end up in courts. So this is an area that will have to be determined by litigation. I'm sure, but there are going to be a number of claims. My own view is that this is the unexpected, and you don't certainly cover yourself to the unexpected. But then, as far as the person who has insured, the policyholder, is concerned, well, he comes and says, look, I'm not worried about what they expected or not. This is what we have suffered under this particular clause. Well, it is a contagious disease that has created this interruption. Therefore, you have to pay. So, as I said, ultimately it may be a political battle, but will be determined only after litigation. And I expect litigation in this early May.
Okay, sir. The other point, I don't know whether you will be at liberty to discuss it, but there's a new issue with regard to reinsurance brokers. Do you want to say something on that? Or?
Yeah, I think so. But anyway, as far as reinsurance is concerned, now this is another issue that has come up now. I mean, no insurance can survive without reinsurance. I mean, if you can take on, I mean, the entire principle of insurance is based on the fact that it is, that it should lie rather than it will be like should be lighter on many than heavily upon a few. So on that basis, reinsurance is opened up, but then we are a little concerned about our judgment lately in the Civil Appellate Court, which is yet under litigation. I mean, under litigation rather, it's going on, where the question is whether a reinsurer has to be registered under every person who is a broker has to be registered with the regulator. Now, normally reinsurance brokers abroad are not registered with us because their position is that they are not doing business in Sri Lanka, they are doing business of Sri Lanka, but not certainly in Sri Lanka. So they are being contacted and done. If that is so, this is going to create a lot of issues. So I don't want to comment much on it because it's yet under litigation and the case is yet pending. But this is an area of much concern, and I hope the industry should look into it very carefully, because this can create a lot of misunderstandings and can create a lot of complications towards the reinsurance business. So I'm just skimming on top because I can't go into the facts of it in depth. Because I will let you know what my personal views are on this matter. But reinsurance is an international business, and the insurance industry survives on that. And then also, as quite like as this and Lloyd's for that matter, will not can't have any direct insurance with anybody. They will always want their brokers to bring in the business, or anyone who wants to come to them will have to go through their brokers. So there are a number of issues in it. So this judgment is going to be of much concern. I hope that will be argued upon and finally a decision will be taken, and that will be taking into consideration the nature and the scope of reinsurance business that is happening right around the world.
Thank you, sir. Thank you for dealing with that. Mr. Fernando, no initial...
My view about that is, Shivan and others, is that you see, you can't evade the law. The law says that the statute law says that no broker can operate in Sri Lanka, insurance broker, without being registered. And it is important, it's a public policy that has to be regulated. And there is a section which says that no insurance broker can operate within Sri Lanka without being registered. Now, because insurance contract is independent of the primary contract, and when an insurance company in Sri Lanka takes over the policy or insures a risk, they send an offer of this to the reinsurance company abroad. Those people accept it, and then the acceptance is taken abroad. So the contract is entered, reinsurance contract is entered outside the country. All reinsurance, particularly Lloyd's, they don't deal directly with you. They always deal through the brokers, and all those brokers are abroad. But I think in this instance, to my knowledge, if I read the judgment, these people have opened up an office in Sri Lanka, for example, like those garment factory buying officers, and they are coordinating it within. So if they do that, if they come here, set up a business, they have to get themselves registered. That is my view, subject to correction on the facts. I don't know. I'm not in the case. As Mr. Razik Saruk, President's Counsel, said, we can't discuss that because that is in pending court. But if you're having an office in Sri Lanka and carrying on business of a broker, then you are coming within the section of the act. You can't evade that, you see. If you are outside, then you must say that you're not doing business in Sri Lanka, you're only coordinating it, the decision is taken outside the country. But if you say that you're doing business in insurance brokering in Sri Lanka, then the section must apply. That is my view, but I may be right or I may be wrong, but let to be seen. But I certainly agree with the President's Council, Mr. Razik Saruf's view that this has created a lot of fear psychology within the reinsurance trade and the insurers, because it is very important. As I mentioned, every insurance company reinsures their portfolios with different multiple reinsurance companies, and they in turn reinsure it. Sometimes they reinsure with, they are compulsorily by statute obliged to reinsure 30% with the NITF, National Insurance Trust Fund, which has to be dealt with by Mr. Razik Saruk. I think he was asking to explain that. And sometimes you reinsure with Sri Lanka Insurance Corporation, which is a reinsurance company, insurance and a reinsurance company. They in turn they have certain portfolios with one reinsurer abroad, another insurance in Malaysia, another insurance in London, like that. So this whole business is going to get interrupted if this people are uncertain as to how this operates. But fundamentally, what I say that you can't evade the statute. If there's a law, it has to be complied with it. Thank you.
Mr. Razik,
No, Rohit, can I come in, Shivan? Shall I come in there?
no,
I don't know.
No, please continue.
No, I think I agree with the President Council, and where the law stands. But then the issue here is not that. The issue is whether they are doing business in Sri Lanka simply because they have a liaison office. Are they doing business in Sri Lanka, or is it only facilitating them to do business of Sri Lanka? I don't know. So this, because as far as we are concerned, we are more interested in the policyholder. Our interest lies on the policyholder. So if it is in his interest that there should be a reinsurance, so we'll have to resolve in terms in favor of the policyholder. So it is correct that the brokers have to be registered, but is it only if they are doing business in Sri Lanka? So that is where the court should have to come in and say, well, look, you are doing business in Sri Lanka, or are you doing business of Sri Lanka out? And we are having an office here purely to facilitate that particular business. So is that business done in Sri Lanka, or is it down or out? So I don't think they are doing it in Sri Lanka. That's my personal view. That they're doing it from out. From out, they are sourcing the various reinsurers. So if not for reinsurance, nothing can be coming back. It is true that we have brought in the National Insurance or Trust Fund into account, but then they are very limited in their scope, because although the government has said they have not been given a ceding. They have been asked to say that all reinsurance has to be done. 30% of the reinsurance has to be done through the NITF. Now, the poor NITF cannot bite more than what it could chew. So they don't have the resources to take in large contingencies, or rather to come in with 30%. So I think unless they themselves go in and take another insurance policy, a reinsurance policy, which they could do under the law. So many reinsurance people do take another reinsurance. That's that particular that concept is permitted. So we do not know. So that they have to look into it. So as far as the NITF is concerned, it has only a limited. Now, for example, if it's a large bottom insurance, I'm sure the NITF won't be able to accept it, take it. So these are matters that will be looked into, the law has been amended. And if at all, the parameters have to be set in, and there should be certain limitations given to the NITF. They cannot take anything. Now look at what has happened to some of the insurance schemes that the government had thought earlier. Now insuring all students and their parents and all that. It is a lot of issues, because those insurance companies were not able to do it, nor could the NITF honor any of those claims. So as a result, ultimately, you have created an issue where people have been given hopes, and they have been given certain opportunities, and those opportunities are not forthcoming. So they are all totally frustrated. So we are inundated with heaps of complaints, heaps of claims, which will ultimately come in. And the same thing, as I foresee, is coming in respect of the COVID business interruptions also. I think this will be a plethora of cases making claims. So interesting times ahead, though it's going to be difficult.
Thank you. Mrs. Gurran, being the Lloyd's representative, what is your view on the reinsurance issue? You're muted, sorry.
It's not from Lloyd's perspective because we only represent the Lloyd's agency that's for marine service and claims, Shivan. But this story of reinsurance is that it has been going on in Sri Lanka for a long period of time. What happened in this case, I think Deepthi will agree with me, is they went and opened an office here and then the industry reacted to that. That was their way of marketing because this particular party has been taking reinsurance from the Sri Lankan market for over 25 years, I would think. So, and they are in the industry practice, there have been brokers representing other reinsurance brokers in Sri Lanka. But because they tendered to for the NITF and they had a presence here, the one insurance broker took him to court. Reinsurance is it's a very complex mechanism because then the insurance company has to arrange treaties. It will be a surplus treaty or I mean, I don't want to be technical, and there is compulsory cession to these treaties. So all this is done through reinsurance brokers. It was done. And there is also facultative cover for selected big risks. So if I just can touch on two clauses which will enlighten the importance of this reinsurance, there is a possibility of asking for a cut-through clause, where the insured, if he is a large insured, will say, look, I must have access to the reinsurance if something goes wrong with the local insurer. Likewise, reinsurers say, I want to have a claims control clause. You have ceded large premiums to me, and if there is a claim in your jurisdiction and your client is in your jurisdiction, I want to investigate. I want to send my loss adjusters. So we are talking of a fairly complex system here. But I think we are going to have lots of, it's going to be interesting and challenging. We can bring in new reinsurers. We can have brokers doing it in a different way. But reinsurers doesn't happen easily. Like Mr. Nihal Fernando mentioned, I remember, he said, the reinsurers have to spend their risk further. You have to go for retrocession. So America, AIG, Japanese, they all share these large risks. It's not the motor, but when it's exposure to fire, flood, tsunami, and so forth, this is a fairly complex process. So the premiums are ceded from one to another based on contracts, exclusion, conditions. Same way when a claim comes, they contribute towards this. So it's a big risk mechanism that works to keep economy stable. So that's my idea of this thing. I don't want to explain treaties and facultative. I mean, Deepthi has done it too. So we use reinsurance brokers to facilitate this, but they don't need to be present here. But there are brokers who could represent reinsurance brokers, and I'm sure there are reinsurers who would like to come and have a presence here. That's my viewpoint from the industry.
Mr.
May I come in for a minute over here?
Yeah.
Shivan?
Go ahead.
Yeah, Shivan, I think the matter that is actually being dealt in court and the matter and some of the matters that was actually dealt by Mr. Saruk, I believe are two different, they have two different perspectives. I believe in the first instance, as Mr. Saruk said and Mr. Nihal Fernando also said that it's sub judice, but perhaps I think when we look at a whole reinsurance transaction, if you look at the manner in which how insurance companies operate in this market, we need to understand that insurance companies actually cannot survive in the market on a standalone basis, and absolute reliance on reinsurance is absolutely necessary. Even if you take Lloyd's of London, although we call it actually the birthplace in insurance, even Lloyd's of London actually have retrocessionary arrangements, and they also reinsure with certain reinsurance companies, maybe based in Bermuda, Isle of Man, or in some place. So basically, it's a risk transfer mechanism. Now, from an insurance company's perspective, when the insurance company, gets into a transaction with a insurance, foreign reinsurance company, it's the internationally accepted market practice that you have to go to a reinsurance company direct. In most instances, maybe about 70% of the transactions are routed through broking companies. So therefore, invariably, insurance company needs to be happy, and insurance company needs to be comfortable with the broking company that they are choosing in order to reach a reinsurance company. And also, depending on the complexity of the market, the expertise of an insurance broker is necessary to assist the company to do that. So I think, these are international transactions, and I know so much of millions pass from insurance companies to reinsurance companies on a monthly basis. And at the same time, reinsurance companies also use the mechanism of international insurance brokers also to pass on the claims monies back and forth to the Sri Lankan market. So it involves fairly a large amount of transactions, either in foreign currency terms or in local rupee terms. So therefore, the insurance company should have the what you call the comfort and the satisfaction of the broker. So therefore, I think in that matter, insofar as the broker doesn't have now, as Mr. Zaruk said, if the broker has an operation here, and as Mr. Nihal Fernando also endorsed, if the broker has an operation here, then obviously IRCSL can intervene and regulate the whole affairs. But then in instances where insurance companies opt to transact with foreign reinsurance companies, with foreign brokers, I think the insurance company should have that liberty. And even if you look at the market today, right, leading broking houses like Marsh, Aon, these are the two big broking houses in the world. They also have their representative officers here. So they have franchised the local brokers. So the question that actually was handled in this case probably is where that particular broker took part in a direct bid for a NITF business. So therefore, I think in my personal view, these are two different aspects that we are talking of. And then, as I know, in view of the order that has been made, the insurance companies are also perturbed today. The brokers are also perturbed. They're in a big dilemma as to the way forward. So therefore, I think a regulatory clarification or interpretation into the aspects or the issues that was dealt in the case would be very useful from an insurance company's perspective, so that this is the year end where the insurance companies mostly get into international reinsurance contract renewals. That's a view from my side.
Can I just butt in for a minute?
Too premature for the regulator. Sorry, too premature for the regulators to come in at this stage because the case, as we said, is pending in court. We said, as Nihal himself would say, sometimes most of the buying officers also have their representatives here doing looking after their interests. So the mere presence of it is a matter whether they are doing business in Sri Lanka or they are facilitating business of Sri Lanka out, is a matter that has to be interpreted in court. So I don't think at this stage we as regulators could walk in right away until the final decision of the court is known to us. So that way we have to be a little cautious. I can't jump in right away unless, of course, the legislature steps in and says, well, look, international reinsurance business is international and then that's exempted, they need not be registered. That's a different issue altogether. The legislature intervened. So we have to await the outcome of the court case.
And Mr. Fernando, you want to say something?
Yeah, you see, Shiva, just to clarify, as litigators, when we appear in court, that very high value cases that we do, we are instructed by the local insurance company, but totally monitored and regulated by the reinsurance lawyers in London. Now, cases that I'm opposed to you and your father, some of the matters very heavy, 1.5 billion cases. We have to even, translate the proxy and send it to them, and they say what every day was. We have to directly deal with them and explain to them what, because they are the reinsurers lawyers in London, Cox and Co. and those famous law firms. For example, shipping, it is Richard Butler, so many. They ask you what happens on a daily basis, because some of the reinsurance contracts, major part of it is reinsured. Sometimes the entirety is reinsured, and the local company gets only a commission. You see, the Coca-Cola flood, I told you that 100% reinsured. Only a commission was given. So those people are naturally interested and they are naturally obliged to be interested. I mean, they're entitled to be interested and regulate the proceedings in a country here. But question is whether you can sit here and do the business or not. Then I think it is the government should take action and the legislature should step in terms of the existing laws, and they can pass directions and regulations and clarify this matter so that the courts are also then bound by it. There must be a committee. I think Mr. Razik, the President's Council will have to deal with that in some day. I don't think it's advisable to wait till the cases, and I don't know, cases go on for years. So I think the legislature should step in and pass some regulations or directions which are binding on the insurance companies. That's my view.
I think we crossed over to the question and answer session time slot. If you all don't mind, there funny, one of the topics that we discussed a couple of days ago has been raised as a question. So I'll put that first to Mr. Fernando. The question is, some mobile phone companies deduct subscription from customers for life insurance schemes without issuing a valid contractual document. When asked, they state that there is a general document, but not with two individual parties. Please discuss the legality of this situation. Sir, Mr. Fernando.
Yes, now this, as I mentioned, we go to fundamentals, basics. What is the basics? There must be a contract. There must be a written contract, either with your mobile provider. The mobile providing contract should provide for it. For example, bank insurance, sometimes they give you insurance. For example, Visa card gives you insurance. If you buy a ticket from a Visa card, that gives you an insurance policy for travel. So, but then the terms and conditions of that issuing that Visa card to you entails those conditions. So fundamentally, there has to be some terms and conditions agreed to by the party who is claiming or the party who is giving the insurance.
No, it got stuck, sir. Mr. Fernando, sorry, Deepthi, until Mr. Fernando comes online, what are your thoughts on that question about the mobile phone insurance schemes?
Well, I think mobile phone insurance, it's actually new to Sri Lanka. Market is experiencing this. But if you look at, if you look at actually, the markets, some of the developed markets, they do telephone binding. Actually, when you say the telcos actually take a predominant position in marketing insurance policies on behalf of insurance companies. So they have underwriters who give them the backing insurance cover, and they come as an intermediary, and then they actually, since they have a wider client base, they reach the client base through their call centers, and the call centers have terms and the telephone operators, and they have pre-written scripts. Based on that, they actually make general offers to the policyholders, and then thereafter what happens is that if a person gives the okay to purchase an insurance policy, then it's being followed up with a pre-printed what you call a document, contract document, also allowing the policyholder the option. That's actually in insurance, it's called a cooling off period. Maybe they give about 30 to 40 days to cancel the policy and ask for a full refund. So actually these transactions by and large happens in the West, and in some parts in major markets like in Japan and Korea, where the insurance penetration actually stands over 90 to 95%. If you take Japan's insurance market is almost 99%. If you take the US market is almost 95%. So there is actually a mechanism by which they do telco insurance. So I think if our market is moving progressively in that regard, these kinds of options, in my personal view, should be made available. But insofar as consumer protection is concerned, you have to build the regulator or whoever who regulates, maybe the telecom regulator or maybe the insurance regulator or joint action by the telecom, what do you call it, telco as well as the insurance regulator. They should bring up rules and then, build in terms and conditions on which how the consumers' rights can be protected to prevent arbitrary selling and becoming nuisance to people, etc., etc. But by and large, these actually schemes really benefit the individuals as well as the markets. Maybe 10% of the people may not like, maybe 20 to 30% of the people may like, some people may ignore. But the fact is, this actually the convenience of buying today in terms of modern e-commerce and all e-based transactions that we are speaking of in the modern day and era, these things do happen in the market. So that's where I think those markets have gone up in that manner. So I think Sri Lanka also should think aloud and see, make a balance between, this kind of propositions, and also while also accepting and acknowledging that consumer rights needs to be protected. That's my view.
Thank you, Deepthi. So, Mr. Razu,
Yeah.
any thoughts on that? Because you were concerned about it as well the other day.
I could hear. Anyway, this is one area, quite rightly, you cannot stop the mobile insurance growth because these platforms have been made use of, and it also penetrates into a deeper, to a different set of people who are unable to otherwise access insurance. So through the mobile network, I mean, there's a category of people who can come in and survive the sector. But only point is, this has to be regulated because there's no insurance policy that is given. There's only a card given, a small card that is given, and if they have a claim or something, they'll have to then go in and check on the policy, go on the internet and check on the policy. Now, how many of them, these people who are having this, I'll say there's a man who plugs in every day 100 rupees onto this as a premium. Now, how is he going to get back? Does he have access to internet or whatever it is to get back to what the policies are, what the policy is? And we do not know also the quantum of premium that is collected. I mean, so much the better. I mean, if the insurance is being spread, it's so much the better from us. We have greater penetration. For example, at the moment, it's only about 1.2% of the total GDP of the country, but we may drive up to about 2% later on. Good. But how are we going to go? We do not know what volumes are being brought in and how many claims are being honored. So these statistics have to come into us. So these things are not available at the moment. So these are new bank assurance, or for that matter, mobile insurance are all good progressive things that are coming in. We can't stop the progress of the electronic, what shall I say, utilization of electronic platforms. But the point is, we have also at the same time got to regulate it and keep a watch on it. So, so sometimes when we keep on asking 101 questions from the because as far as we are concerned, we are policyholder. So to look after the interests of the policyholder, when we have asked all sorts of questions and queries, give us this information, I think the industry is also a little annoyed and perturbed that we are over-regulating or we are trying to over-regulate. No, but we should know this because on the mobile platform, they could go into, as somebody said, into millions or billions. So what would be their payback and how much of it are they meeting the claims from? What are the claims that are coming up? So these are areas that we have to look into. In as much as we don't want to stop the growth of the mobile platform or bank assurance, for that matter, we would like to know to what extent are they credible, or to what extent are they being accepted, or how is it being done? So to that extent, as a regulatory body, we will have to interfere and we'll have to look into it. Not interfere, we'll have to intervene and look into it. So that is where it stands, and it's taken us rather. This is something that is really the Commission is very much concerned about today.
Thank you, sir. Mr. Fernando, I think there is a question specifically for you. It says specifically in relation to construction contracts, should cost runs due to COVID be taken by the employee or the contractor with regards to prolongation of work due to curfew?
That's a real double-barrel question. But I think all contractors are obliged, in my view, most of the building contracts, there is a clause which says that the contractor should take a, what you call a all risk policy. They are obliged to take a all risk policy. So question is whether the all risk policy has an endorsement for COVID, for contagious diseases. Again, you get back to the same principle of what the peril that is covered or not. So you go to basics and see every contractor is obliged to take a all risk policy. In that all risk policy, business interruption, whether they have covered it or not, is a matter that to be dealt with. So it is certainly I don't think if the policy of insurance, the owner or the employer was contemplated that the all risk policy should contain a pandemic cover, very unlikely. So that I don't think is unreasonable in my view to expect a contractor to obtain a pandemic cover and the employer to expect that kind of thing. Now, of course, big projects like all these apartment complexes, hotels that are coming up, the employer will insist that the contractor takes a pandemic cover because they are funding it large amounts, billions of rupees, and there's a time period of conclusion, and they have budgets, they have programs, are cash flow, income, opening dates are all set. So in those circumstances, I think now the industry will have to develop this kind of policies, pandemic cover policies, which will be in the contemplation of the parties at the time of entering into those contracts. So once again, my view is that it is basic to go back to the all risk policy, and with that entails a BI cover on these lines.
Thank you, sir. Deepthi, there is a question directed at you as well. It reads,
Yeah.
the recent quote about drunk and drive. I'm reading. Sir, any action taken so far by the industry or IRCSL? There are insurers who expressly exclude drunk and drive. Do you think insurer can continue with such exclusion, or insurer should remove the exclusion? Sorry, it's a bit of a long question. Did you
No,
get it?
I can answer that. I think it's very clear now, Shivan. The law is settled with the Supreme Court judgment, which was explained to us by Mr. Nihal Fernando. So no declaration on non-liability actions would be granted, where even in the event where the insured driver has been drunk. So I think it's a public policy thing, because if you look at the whole Motor Traffic Act, the protection was actually built in to ensure that in the hands of errant drivers, the poor public are protected. So basically, I think that was actually what was contemplated in the law when it was actually promulgated in 1958, or the 1958 Motor Traffic Act. It also had the provisions, because it had a provision for contesting liability by the insurance company in the event if the insured has been in breach of the contractual terms and obligations. But if you look at the development of the international law, right, so you have rights of, now for instance, if you since you studied in England, you will know there are acts in the Western world which actually protects the rights of third parties within the purview of insurance contracts. So this is the whole aspect of liability. Now, for instance, in a liability type of insurance, as Mr. Fernando explained, the liability insurance today is governed under the delictual law, and the law is primarily based on the South African Roman Dutch law. So now the point is, what happens that if when a innocent third party gets affected, he has no status within the framework of an insurance contract between the insurer and the insurance company. But whereas he is a person who is being affected, so therefore, for the fault of the insured, for breach of terms by the insured, the question arises whether an innocent victim should pay the price. So because the insurance companies have been moving in the direction saying that the insured, or maybe citing vicarious liability, insured should have supervised, etc., etc. And finally, who becomes victim to the whole issue is that the victim becomes a double victim. One is in the hands of the poor motorist, errant motorist, he becomes a victim. And then in the hands of the insurance company's declaration on non-liability, he gets the second hit. So therefore, I think the decision that the Supreme Court has made, Supreme Court has announced, I think is absolutely noteworthy, and then it's highly commendable. So I think the law, as far as the Motor Traffic Act and the drunken driving is concerned, it has settled insofar as the third parties are concerned. But if you take your own thing now, where you have the drunken driving exclusion under a policy of insurance. So if there is any damage to the insured's motor vehicle, then obviously the insurance company can set in and insurance company can deny liability, because no insurance company would expect the insured or any of the insured's agents to drive the vehicle in a state of drunkenness, in an intoxicating condition. So therefore, denying a claim to the insured is okay, it's legitimate. But I think denying a claim to a poor victim who has become a victim of the insured's negligence should be accommodated. And I think the policy of the law is now very clear in that aspect, because there was a policy of the law, there were varying interpretations, but with the Supreme Court judgment, I think the matter will settle and then the matter can be put to rest thereafter. I welcome that.
Thank you, Deepthi.
I think, can I just butt in for a minute? I think he's absolutely correct in that, because that third party insurance liability is only in respect of personal injury and death, not for property damage also. So it is limited. So in that context, I think it is very reasonable to contend that the third parties who are personally injured or there is death, and they has to be compensated in these circumstances. But if you go and knock a wall, the owner of that person, that owner of that house can't claim from the insurance company. It is, it's only personal injury and death. So in those circumstances, I think it's absolutely right and it's a good judgment.
Thank you, sir. And like I said, I'm biased towards the judge for obvious reasons, but I mean, Justice, Lordship Justice Amrasekaran went through the legislative process from the early 1900s to explain why third-party cover was made compulsory. Following on from that, Mrs. Gunrat, this is a quick question.
Yeah.
It's a non-fault-based liability. Now, overseas, there are, like in New Zealand, they have, accident compensation funds for third parties who have got injured rather than having to go to court or whatever. Is there any possibility of those being set up here without the law changing to make it a non-fault-based system? Or
Yeah, as a business enterprise for underwriting and for insurance, they would look at the profitability of something like that. So no private sector company is going to come in, and then, as Mrs. Aruk said, these schemes that have been started, they can't see their way through even if you do that. So I don't think funds can be set up. But on this interesting question stemming from what Deepthi said and what Mr. Nihal Fernando said, I was wondering, what about the rights of recovery of the insurance company? Okay, the law says you can't go behind drunken driver, but we say that we have the right of recovery from the wrongdoer. It's just a matter for us to think. I mean, I'm with the judgment, but then will the insurance company keep on getting blamed for all drunken people who are going to drive and start paying compensation? Just a thought.
Just on that fun question, sir, Mrs. Arun. Yeah, just on, it's just that, I mean, like I said, in New Zealand, this funds are created by adding a certain amount by the government from the petrol prices or whatever. Is there a likelihood that such a thing would be taken up in Sri Lanka or not? No one has thought about it yet.
No one has thought about it yet, but it's a good idea, Shivan, that they should do that. There should be some fund created out of it.
Shivan, just an observation from my side here. Now, actually, do you know that there is something called the Road Safety Fund? And the Road Safety Fund, to the Road Safety Fund, insurance companies are required to contribute 3% of their third-party insurance premium to the Road Safety Fund. And the Road Safety Fund is expected to compensate victims where the insured is unknown, where let's say there are hit and run cases. So hit and run cases, victims can obviously, have recourse to the third party, what you call this Road Safety Fund. I believe it is being administered under the Motor Traffic Act by the Motor Traffic Commissioner. So there is a mechanism, but the point is the compensation that's being allowed is very meager there. So that's one thing. And then also, Shivan, I remember about 6-7 years ago, before the amendment to the present Motor Traffic Act was contemplated, there was a draft that was under circulation which suggested a no-fault optional compensation scheme to have been introduced, because there was a proposal to that effect, because it was optional compensation. So therefore, it was in discussion stage. Insurance companies also welcomed it, because, rather than relying on litigation, you create maybe a tribunal or something like that. And there, if the person opts not to contest liability, but on a no fault basis, like in New Zealand, if the person desires to get some compensation on those aspects, so there was a limited compensation formula that was offered. But this didn't go through legislation when the Motor Traffic Act was amended on the very last occasion. It came out without this particular section, which was actually subject to intense discussion with the insurance industry as well.
Just a quick rejoinder.
I think that's important.
I believe the role of the ombudsman, for example, he can decide on that. Though the motor traffic commissioner has the fund, the ombudsman can decide on the claim rather than going to litigation.
Thank you, sir.
Yeah, so you can actually create a nexus. Yeah.
Can I come in, Shivan? Yeah. Now the point is, this was, as quite rightly Deepthi said, this no-fault insurance is at the moment they are in England. So what happens in Sri Lanka is that insurance companies are obliged to pay in terms of the Act, Motor Traffic Act, only if they are liable. If the owner is liable, then you're obliged to satisfy the decree. So if you take that liability part of it out by statutorily, then no-fault insurance comes in, and it's only the quantum. Of course, in Sri Lanka, if the damage is 10,000, they'll claim about ₹1 million. So there'll be a contest. If you can regulate it by legislature to take away the liability part of it and say no-fault insurance and only the quantum to be contested, then I think that will be a very, very good suggestion. It should come in by legislation, not by anyone else. It was contemplated, as Deepthi said. In England, it is at the moment they are not even in New Zealand. Even in England, there are no-fault insurance.
Okay, thank you. There is one more question. I think have about 3 minutes. Mr. Fernando, I think you. The question is, sir, I have a common question that as per section 3 of the Civil Law Ordinance, most of the commercial law subjects are governed by English law, and our common law is Roman Dutch law. Could you please explain what are the areas of commercial law governed by Roman Dutch law? Not purely insurance, but
Actually,
did you?
Commerce and actually commerce and merchandise is all governed by English law. And in addition to what is there in the introduction of English law ordinance, for example, like the Carriage of Goods Act, where they have all these conventions have been brought in, Hague rules have been brought in. So all those things have by statutorily changed. It is to look at what law applies. For example, evidence ordinance says that English law will apply if there's a lacuna. So now that is not there in the introduction of English law ordinance. So you can't look at the introduction of English law ordinance, which is what we call the civil law ordinance, alone to see wherever English law applies. So particularly marine matters, shipping matters, aviation matters, all commerce, merchandise, banking, all that is there in the Act itself. It applies, all English law applies. Rest and residue comes under Roman Dutch law. I can give you one example. There was a judgment, a dissenting judgment of Justice Citrasiri, who is very, very clever in his research. I argued that insurance, surety bond, insurance sureties, insurance companies issue bonds. Insurance bond for a guarantee bond or an indemnity bond or insurance bond is governed by and the same principle. If there is no exclusion of the beneficiaries and the proportionate those two clauses, then the Roman Dutch law principle should apply. He held with me on that. But the other two judges said no, because it's a commercial transaction, it has to go through. But in my view, at that time, I argued that no, a surety bond issued by an insurance company is a different insurance bond, and that has to be governed by Roman Dutch law. And then, so there is a doubt in that also. There are judgments for and against that. But all bank guarantees, because it is banking, is governed by English law. But whether insurance guarantees come under English law or not, in my view, it is South African law and those principles apply. But so there are judgments on against both parties, the both ways.
I think we've come to the end of our session. I take this opportunity to thank all for spending nearly 2.5 hours on the webinar and on a Saturday. I'm sure they would have better things to do at this time. But once again, thank you for sharing your thoughts and your practical knowledge. I'm sure all of us who were listening have learned a lot from this webinar. So thank you very much, and thank you to all.
Thank you, Shivan.
Thank you very much.
Fernando.
Thank you very much,
Thank you,
Shivan. Thanks a lot.
Nami, and thank
Thanks
you all for
everybody. Thank
listening.
you.
Right.
Thank you, Shivan. Thank you very
Razik,
much.
Business Council, Deepthi.